The alarm went off at 4:30 in the morning, but Samuel Walker had already been awake for an hour. He sat at the kitchen table of his modest home in southwest Atlanta, the kind of neighborhood where people still waved at each other from their porches and knew each other's names. The overhead light cast a warm yellow glow over the table, and spread across that table, organized with a precision that would have impressed any commanding officer, were dozens of documents, folders, photographs, maps with handwritten notes in the margins, certified letters with official seals, property records dating back to the 1940s. Samuel picked up his coffee mug, took a slow sip, and looked at everything one more time. He was not a nervous man by nature. 31 years in the United States Army had a way of reorganizing a person's relationship with fear. He had served in conditions where paperwork was the last thing on anyone's mind, where decisions made in seconds determined whether people went home or did not. He had risen through the ranks with discipline, with honesty, and with a stubbornness about doing things the right way, even when the easier path was right in front of him. He had retired as a major, respected by the people who served with him and by the people who commanded him. After leaving the military, he had built a second career in risk management consulting, advising large organizations on how to identify vulnerabilities before those vulnerabilities became disasters. Samuel Walker knew how to prepare for high-stakes situations. And yet, as he sat at that kitchen table in the early morning darkness, reorganizing what was already perfectly organized, he allowed himself to feel the weight of what this day meant. The property had been in his family since 1947. His grandfather, James Walker, had purchased the land with money saved over 15 years of working in construction, in a time when black men in Georgia were not supposed to own land, were not supposed to have assets, were not supposed to build anything that lasted. James had built a modest house on that land, then expanded it. His children had grown up there. His grandchildren had played in the backyard. The address itself was encoded in the Walker family's memory, the way a song is remembered not just in the mind, but somewhere deeper, somewhere closer to the chest. 3 months ago, a company called Meridian Property Holdings had filed a claim asserting that the Walker family did not have clear legal title to approximately 2 acres of the property. The claim was based on what Meridian described as a chain of title deficiency from the 1960s, a period when the property had apparently gone through a complicated inheritance process following James Walker's death. Meridian had purchased adjacent commercial land and was now expanding its footprint. The Walker property, they argued, was legally in question. Samuel had read the claim 3 times the night he received it. Then he had sat quietly in his living room for a long time. He had considered hiring an attorney. He had consulted with 2 of them. One told him the case was too complicated for the value of the property to justify the legal fees. The other told him he might have a case, but it would take years and significant financial investment to pursue. Samuel had thanked both attorneys for their time, shaken their hands, and driven home. Then he had started doing what he had always done in the face of a complex problem. He had started pulling threads. Over the following 8 weeks, Samuel had visited the Fulton County Register of Deeds 6 times. He had driven to the Georgia Archives in Morrow. He had contacted the Veterans Administration not because the VA was directly relevant to the property dispute, but because certain federal records involving land purchases by veterans from the 1940s contained supplementary documentation that cross-referenced county records. He had spent hours on the phone with clerks, with archivists, with a retired land surveyor he found through a mutual acquaintance. What he had found, layer by careful layer, was a story. And on the morning of October 14th, with the autumn air coming through the kitchen window and the city of Atlanta still mostly asleep, Samuel Walker placed every document into its designated folder, slid each folder into his briefcase, and closed the latch with a quiet click. He dressed carefully, not expensively, because expense was not the point. He chose a dark navy blazer, pressed slacks, a white dress shirt, and a tie his late wife, Carolyn, had given him for their 30th anniversary. He stood in front of the bathroom mirror for a moment, adjusted the tie, and looked at himself. He was 59 years old. His hair had gone almost completely gray in the last decade, which people sometimes commented on as though it were something to apologize for. He did not see it that way. Gray hair meant he had been paying attention. He picked up his briefcase, turned off the kitchen light, and drove to Fulton County Superior Court. He arrived at 7:15, more than 2 hours before his scheduled hearing. The courthouse was a large stone building in downtown Atlanta, its exterior reflecting the kind of institutional permanence that was meant to communicate authority and impartiality. Samuel parked in the public lot, walked through the main entrance, passed through security, and found the corridor outside courtroom 14B. He sat on a wooden bench in the hallway and opened his briefcase one more time. He reviewed his notes. He organized his arguments. He thought through every question he might be asked and every document he might need to reference. At 8:45, a woman arrived in a tailored charcoal suit, accompanied by 2 younger colleagues carrying boxes of files. She was Lisa Monroe, the lead attorney for Meridian Property Holdings. Samuel had looked her up. She was 41, a senior partner at a well-regarded Atlanta firm, with a track record in commercial real estate litigation that was genuinely impressive. She walked past him without looking at him, and one of her colleagues glanced briefly at Samuel with an expression that was not quite pity and not quite contempt, but contained elements of both. Samuel said nothing. He watched them enter the courtroom. A court officer came to the door at 9:05 and indicated that the hearing was about to begin. Samuel stood, straightened his jacket, picked up his briefcase, and walked in. Courtroom 14B was medium-sized, formal, with wood paneling, fluorescent lighting, and the particular smell of old paper and air conditioning that courtrooms everywhere seemed to share. There were perhaps 20 people in the gallery, a mix of journalists, law students, and a small group that Samuel recognized as members of his own family. His daughter, Vanessa, 31 years old and a registered nurse, sat in the second row with his brother, Calvin. She gave him a small nod when he entered. He nodded back. Samuel placed his briefcase at the respondent's table and sat down. Across from him, at the petitioner's table, Lisa Monroe arranged her materials with efficient professionalism. She had a legal team. She had boxes of documentation. She had the weight of a large corporation behind her. Samuel had a briefcase. The gallery murmured. He caught fragments of whispered conversation, the kind that people do not think can be heard, but often can. He is representing himself against that firm. That is either brave or foolish. Probably foolish. Samuel folded his hands on the table and waited. At 9:12, the Honorable Harold Whitman entered the courtroom. Everyone rose. Whitman was 63, a heavy-set man with steel-gray hair and the bearing of someone who had spent decades being the most powerful person in any room he entered. He had a reputation as an intelligent judge, thorough in his legal analysis, but also known for impatience, for interrupting attorneys he felt were wasting time, and for a dry, cutting wit that he deployed without hesitation when he felt a proceedings was beneath the court's dignity. He settled into his chair, adjusted his glasses, and looked at the 2 tables before him. His eyes moved from Lisa Monroe and her team to Samuel Walker, sitting alone. There was a pause, Judge Whitman said, in a voice that carried across the entire courtroom, and the respondent is representing himself today. Yes, Your Honor, Samuel said. Another pause. Something moved behind the judge's eyes, a quick assessment, a forming of a conclusion. Very well, Whitman said, with a flatness in his tone that communicated, without quite saying it directly, that he had already calibrated his expectations accordingly. Let's see how this goes. And in the gallery, someone laughed. A brief, quiet laugh, quickly suppressed but audible. Samuel heard it. He did not look in that direction. He kept his eyes on the judge. He had prepared for this too. Judge Whitman called the proceedings to order and invited the petitioner to present its opening position. Lisa Monroe rose smoothly. She was composed, assured, the kind of attorney who seemed to carry the expectation of victory the way other people carry a briefcase. She thanked the court, acknowledged the respondent across the table with a brief nod that was perfectly calibrated to seem professional without being warm, and began. The core of Meridian's argument was methodical and, on the surface, convincing. She described the company's due diligence process prior to purchasing the adjacent commercial parcel. She outlined the title search that had been conducted, which revealed what she characterized as a significant gap in the documented chain of ownership for the Walker property during a specific period in the 1960s. She presented a timeline, printed on presentation quality paper, that showed the sequence of recorded deeds and identified the years in question where, according to Meridian's research, no clear transfer of title could be confirmed. She spoke for 22 minutes. She was precise, unhurried, and never lost her place. When she finished, Judge Whitman made a note on his legal pad, looked at Samuel, and said, "Mr. Walker, your response?" Samuel stood. He did not have a presentation on printed paper. He did not have a colleague to hand him documents. He placed his briefcase on the table, opened it, and removed a single folder. "Your Honor," he said, "I appreciate the court's time this morning. I want to be straightforward with you. I'm going to walk through the facts as I've been able to establish them, and then I'm going to ask the court to make one phone call. Just one. That call will confirm everything I'm about to present." Judge Whitman's expression shifted slightly. "One phone call," he repeated. "Yes, Your Honor." "Mr. Walker, this is a formal legal proceeding. We're not here to make phone calls." "I understand that, Your Honor. I'll ask for the call at the appropriate point. I'd just like the court to hear the background first." Whitman leaned back slightly and made a gesture with his hand that was not quite dismissive but was close. "Go ahead." Samuel nodded and began. He started with his grandfather, James Walker, and the original purchase of the property in 1947. He described the conditions under which the purchase was made, not as an appeal to sympathy, but as context, because the conditions of that era had a direct bearing on how the records were created and maintained. James Walker had purchased the land through an arrangement that was common among black property owners in Georgia at the time, involving a third-party holding structure that was designed to protect the purchase from challenges that were openly discussed as real possibilities. The legal mechanism used had been formally recognized by Fulton County at the time, but was not a standard deed transfer, which was why it did not appear in the typical chain of title search, the way a conventional transaction would. Judge Whitman interrupted. "Mr. Walker, I'm going to stop you there. Are you familiar with what a chain of title search is? Technically speaking, yes, Your Honor. A chain of title is the sequence of historical transfers of title to a property, tracing from the original owner to the current owner. A gap in that chain creates a cloud on the title, which can affect the owner's ability to demonstrate clear ownership." The judge blinked. One of the attorneys at Monroe's table shifted in her seat. "Good," Whitman said, in a tone that was not unkind but contained a note of surprise that he did not particularly try to conceal. "Continue," Samuel continued. He described the inheritance of the property following James Walker's death in 1963. He explained that the property had passed to his grandmother, Ruth, under the terms of a handwritten will that had been filed with the county probate court. He produced a certified copy of that filing. He placed it on the table and referenced it by exhibit designation, the way he had seen attorneys do in the legal documents he had read over the preceding months. He then described what Meridian's title search had apparently missed. In 1968, the property had been the subject of a tax lien proceeding, following a period during which Ruth Walker had struggled financially after a medical situation. The lien had been filed, and then, in 1970, it had been resolved and formally released. The release of the lien had been recorded not with the Fulton County Register of Deeds, where standard property transactions were recorded, but with a separate administrative office that had since been reorganized and absorbed into a different county department. The record existed. It was a legitimate, official document, but it existed in a place that a standard title search would not automatically look. Samuel knew this because he had looked there. He had found the record on his 4th visit to the Georgia archives. He produced a copy of it now. He placed it beside the other documents on the table. Then he looked up at the judge. "Your Honor," he said, "the petitioner's position rests on the assumption that there is no recorded resolution to the 1968 lien. That assumption is incorrect. The resolution exists. It is official. It was properly filed in 1970, with the office then designated to receive it. I have a copy of that record here, but I understand that a copy is not the same as verification, which is why I'd like to ask the court to make one phone call to confirm the existence of the original record with the Fulton County Department of Records and Archives. There was a pause. Judge Whitman looked at the documents on the table. Then he looked at Lisa Monroe. Monroe stood immediately. Your Honor, the respondent is presenting documents that have not been submitted through proper discovery channels. Furthermore, a phone call to a county department is not a recognized method of authenticating evidence in these proceedings. I'm aware of that, Whitman said without looking at her. He looked at Samuel. Mr. Walker, he said, and his voice had shifted in a way that was subtle but perceptible. These documents you've placed on the table, are they certified copies? They are, Your Honor. Each one bears the certification seal of the issuing office. I also have the original certification letters in a separate folder if the court wishes to examine them. Whitman was quiet for a moment. He looked at the documents again. He removed his glasses, cleaned them slowly with a cloth from his breast pocket, put them back on. Then he said something that nobody in the courtroom had expected. Mr. Walker, he said, I owe you an apology. A silence fell. When you walked in here this morning, representing yourself, I made an assumption. I made it quickly, and I made it without sufficient basis. I implied, through my tone and through my reaction to your presence here, that I had already drawn conclusions about how this proceeding would go. He paused. That was not appropriate conduct for this bench, and I want to acknowledge it directly. He turned to the court clerk. Daniel. The clerk, Daniel Ruiz, looked up from his workstation. I want you to locate the contact number for the Fulton County Department of Records and Archives, specifically the division responsible for historical lien records from the 1960s through 1980s. And I want you to place a call on behalf of this court to verify the existence of the record Mr. Walker has referenced. Can you do that? Daniel Ruiz nodded. Yes, Your Honor. Good, Whitman said. We'll take a 15-minute recess while that call is made. This court is in recess. He struck his gavel once. In the gallery, nobody spoke for a full 5 seconds. Samuel Walker sat back down, folded his hands on the table, and looked at the documents in front of him. His expression had not changed. He had known what the call would find. He had checked the record himself. He had made his own call to that same department 3 weeks ago, spoken to a senior archivist named Patricia Hawthorne, and confirmed not just the existence of the record, but its precise location within the filing system. He had prepared for this. Across the table, Lisa Monroe was leaning close to one of her colleagues, speaking in a low, urgent voice. Her earlier composure had developed a crack in it, small but visible. Samuel did not look at her for long. He looked instead toward the gallery, found his daughter Vanessa's face, and gave her the same small nod he had given her when he walked in. She pressed her hand briefly over her heart. He turned back to his documents and waited for the recess to end. Daniel Ruiz placed the call from a phone at the clerk's station at 9:57 in the morning. He had located the number for the Fulton County Department of Records and Archives within 4 minutes, specifically the Historical Property Records Division, which was on the 3rd floor of a county administrative building on Pryor Street. He dialed, identified himself as the court clerk for Courtroom 14B of Fulton County Superior Court, and explained that he was calling on behalf of the presiding judge to verify the existence of a specific historical record. The person who answered was a record specialist named Gary Odem. Ruiz explained the nature of the record in question. A lien release filed in 1970 relating to a property at the Walker family address in southwest Atlanta. He provided the parcel identification number that Samuel had written in clean, precise handwriting at the top of his reference sheet, which Ruiz had been handed before the recess began. There was a pause on the line while Odem entered the information into the record system. Ruiz waited. He had a notepad in front of him and a pen in his hand. Then Odem came back on the line. What he said took approximately 90 seconds to convey in full. Ruiz wrote as quickly as he could, his pen moving across the notepad in a rapid but legible script. When Odem finished, Ruiz read back the key details to confirm accuracy. Odem confirmed each one. Ruiz thanked him, asked him to stand by in case the court needed additional verification, and ended the call. He looked at what he had written on the notepad. Then he walked to the door of the judge's chambers and knocked. Inside the courtroom, the 15-minute recess had stretched to 23 minutes. The gallery, which had been buzzing with quiet conversation for the first 10 minutes, had grown increasingly still as time passed. Something about the extension of the recess had communicated to everyone present that whatever was happening in the judge's chambers was not routine. Lisa Monroe sat at her table with her legal team. One of her colleagues, a young associate named Brian, had opened a laptop and was apparently conducting research at speed, navigating between tabs with the slightly frantic energy of someone trying to locate something that keeps not being where they expect it to be. Monroe herself was calm in appearance, but the quality of her calm had changed. It was the calm of someone actively managing their composure, rather than the calm of someone who had nothing to manage. In the gallery, Vanessa Walker sat with her Uncle Calvin and did not speak. She was a registered nurse, accustomed to waiting rooms and to the particular anxiety of waiting for information that would determine what came next. She watched the door to the judge's chambers and kept her hands still in her lap. Calvin, who was 64 and had known Samuel their entire lives, leaned over once and said quietly, "He prepared, Van. He prepared for all of it." She nodded without looking away from the door. At 10:21, Judge Whitman returned to the bench. Everyone rose. He settled into his chair, adjusted the materials in front of him, and looked at the courtroom with an expression that had undergone a visible change from the expression he had carried when he entered that morning. There was less of the casual authority in it now, the reflexive assumption of the landscape. There was something more deliberate in its place, something that looked, if you knew what you were looking for, like a man recalibrating. "Be seated," he said. He looked at Ruiz. "Daniel, please share with the court what you confirmed during the recess." Ruiz stood and read from his notepad. The Fulton County Department of Records and Archives had confirmed the existence of a lien release document filed on March 15, 1970, pertaining to the Walker property. The document was recorded under the filing system of the former Office of Tax Lien Administration, which had been merged into the current Department of Records and Archives in 1984. The record was intact, had not been modified, and bore the original certification seal of the county. The parcel identification number matched precisely. The name of the property owner at the time of filing matched. The lien amount and the confirmation of its full resolution were both documented within the record. The record, in short, was exactly what Samuel Walker had said it was. Ruiz finished reading and sat down. The courtroom was quiet. Judge Whitman took off his glasses. He held them in one hand and looked at the far wall for a moment with the expression of a man doing something private in a public space, absorbing something, adjusting to it, deciding how to carry it forward. Then he put his glasses back on and looked at Lisa Monroe. "Ms. Monroe," he said, "in light of what the court has just confirmed, I'd like to hear from you. Specifically, I'd like to know whether your firm's title search included a review of records held by the former Office of Tax Lien Administration or its successor entity within the Department of Records and Archives." Monroe stood. Her posture was still professional. Her voice was controlled. "Your Honor, our title search followed standard protocols for Fulton County property transactions. The records held by the former Office of Tax Lien Administration were not flagged in those standard protocols as a required search location." "Are they now?" Whitman asked. A brief pause. "I would need to consult with our title research team to confirm." "Ms. Monroe," Whitman said without raising his voice, "the record that just confirmed the clear title of this property has been sitting in a county archive for 54 years. It is not hidden. It is not sealed. It is accessible to anyone who looks for it in the right place." He paused. "Mr. Walker found it. He found it while representing himself, without a legal team, in his kitchen or wherever it is a man does his homework." Another pause. "Does your firm have anything to add at this time?" Monroe stood very still. Then she said, "Your Honor, Meridian Property Holdings was not aware of this record at the time of filing. If the record confirms clear title as indicated, our firm will need to review the implications for the petition." "That seems wise," Whitman said. He turned to Samuel. "Mr. Walker," he said, "I want to say something to you, and I want to say it clearly. In this courtroom, in front of everyone present." Samuel met the judge's eyes and waited. "When you walked through that door this morning, I formed an impression of this proceeding before you had said a single word. I communicated that impression through my conduct. I allowed commentary that was inappropriate to this court's standards, and I did not extend to you the same presumption of competence that I would have extended to any credentialed attorney standing at your table." He paused. "I was wrong to do that, and I am saying so here, on the record, because it matters that it be said." The courtroom was absolutely still. "You came here today with facts," Whitman continued. "You came here prepared, organized, and respectful of this process, even when this process did not extend the same respect to you. That is a standard of conduct that reflects well on you, and that this court should have matched from the beginning." He looked down at his legal pad for a moment, then back up. "This court will be in recess while I review the full record submitted by the respondent. We will reconvene at 1 o'clock this afternoon. At that time, I will render a determination on the petition." He paused. "Mr. Walker, thank you for your patience." Samuel nodded once. "Thank you, Your Honor." The gavel struck. The courtroom came alive again, a wave of murmured conversation and movement. Monroe turned to her colleagues and began speaking in a low, urgent voice. Journalists in the gallery were writing quickly. Several people in the gallery were looking at Samuel with expressions that had shifted significantly from the expressions they had brought into the room with them that morning. Samuel closed his briefcase, stood, straightened his jacket, and walked toward the gallery railing where his daughter was already on her feet. Her eyes bright, one hand pressed over her mouth. He reached the railing. She reached through and took his hand. "Dad?" she said. "Not yet," he said quietly. "This afternoon. Let's wait for this afternoon." But he allowed himself, for just a moment, to hold her hand. The lunch recess lasted nearly 3 hours. Samuel did not go far. He walked 2 blocks from the courthouse to a small diner on Broad Street that he had eaten at before on occasions when he had business downtown. It was the kind of place that had been in the same location for 30 years, with red vinyl booths, a counter with spinning stools, and a menu written on a chalkboard that hadn't changed significantly in the last decade. The kind of place where nobody paid much attention to who you were or what was happening in your life. He ordered coffee and a grilled chicken sandwich and ate slowly. Calvin sat across from him. Vanessa had gone to a nearby pharmacy to pick up a prescription and was going to meet them back at the courthouse by 12:30. It was just the 2 of them in the booth, coffee cups between them, the ambient noise of the diner providing a comfortable buffer. Calvin had been watching his younger brother with a mix of pride and something harder to name, something that sat closer to grief, or to the particular pain of witnessing someone you love be treated in a way they did not deserve. And knowing that this was not the first time, and would probably not be the last. "You knew all along," Calvin said. "It was not a question. I knew what the record said," Samuel replied. "I knew what was there if someone looked. You could have told that judge to go straight to where he belonged when he started with that tone." Samuel looked at his coffee. "What would that have accomplished?" "Your dignity. I had my dignity the whole time." He said it simply, without heat. "The question was whether I wanted to make a point or win the case. You can't always do both. I wanted to win the case." Calvin was quiet for a moment. Then he said, "Grandpa James would have liked today." Samuel smiled. It was a real smile, the first fully unguarded one he had permitted himself since the morning. He would have liked the part where the judge had to sit there and listen. He really would. They sat for a few minutes without talking. The diner moved around them, orders called from the counter, the clink of dishes, the low murmur of a television in the corner showing a midday news program. Nobody in the diner knew that the quiet man in the navy blazer eating a grilled chicken sandwich had just spent the morning making one of the larger corporate law firms in Atlanta reconsider a case it had considered unwinnable. Samuel finished his sandwich and leaned back against the booth. "The house," he said. Calvin looked at him. "Every time I think about what they were trying to do," Samuel said, "I don't think about the money. I don't think about the legal fees or the property value or what Meridian wanted to do with the land." He paused. "I think about the backyard. I think about those concrete steps at the back of the house where Grandpa James used to sit on Sunday afternoons and watch the neighborhood. Those steps are still there, same ones, 50 years old and still holding." Calvin nodded slowly. He knew the steps. He had sat on them himself more times than he could count. "That's what this was about," Samuel said. "Those steps, that house, what that man built." He picked up his coffee cup and drank what was left. "Come on," he said. "Let's get back." They walked back through the midday Atlanta streets, through the dry, cool air of the October afternoon, through the shadows that the downtown buildings threw across the sidewalks in long, angular shapes, back to the courthouse where something was waiting to be finished. Inside the courthouse, the atmosphere had changed from the morning. Word had moved through the building the way word does in institutions where people are paying attention, which is to say quickly and imperfectly, but with enough accuracy to communicate the general shape of what had occurred. Court officers who had not been in the room that morning had heard versions of it. Law clerks from other courtrooms had heard. A reporter from the Atlanta Journal-Constitution who had been in the gallery had made a call. Samuel passed through the security checkpoint, nodded at the officer who recognized him from the morning, and walked back to the corridor outside courtroom 14B. At 12:50, Lisa Monroe arrived. She came alone this time, without her associate Brian, without the boxes of files. She stopped when she saw Samuel sitting on the bench in the corridor. She looked at him for a moment. Then she walked toward him. He stood when she approached. "Mr. Walker," she said. "Miss Monroe." She was quiet for a moment. "I want to tell you that I reviewed everything during the recess. We looked at the record that was confirmed. We looked at our title search methodology." She paused. "The gap in the search protocol was real. We should have looked in that archive location. We didn't." "I appreciate you saying that," Samuel said. "Meridian's position on this will be changing," she said. "I can't speak to the specifics in this corridor, but I want you to know that what I'm going to say in there this afternoon reflects a genuine reassessment, not a tactical pivot." Samuel looked at her for a moment. "I believe you," he said. Something moved in her expression, something that looked like it might have been gratitude for not being argued with. "You were very prepared today," she said. "I was caught off guard, and I shouldn't have been, and I am a professional who does not like being caught off guard." "For what it's worth," Samuel said, "I've read your case history. You're a very capable attorney. The gap was in the research, not in you." She looked at him with an expression that suggested she was reassessing something. "Thank you," she said. A court officer appeared at the door of 14B. "We're reconvening in 5 minutes." Monroe gave Samuel a small nod and walked into the courtroom. Samuel stood in the corridor alone for a moment. The building hummed around him, its institutional sounds, the distant echo of voices, the hum of ventilation, the muffled sound of a gavel somewhere down the hall. He thought briefly about his grandfather James, about the years of saving, about what it meant to build something and know that it could be taken, and to build it anyway. He picked up his briefcase and walked through the door. At 1:03 in the afternoon, Judge Harold Whitman returned to the bench for the final time that day. The courtroom had filled. There were more people in the gallery now than there had been in the morning, drawn by whatever version of the morning's events had circulated through the courthouse during the recess. Law clerks from adjacent courtrooms, a second reporter. Several people Samuel did not recognize who had the look of legal professionals who had found a reason to be in the vicinity of something significant. Whitman settled into his chair, arranged his materials, and looked at both tables. His expression was composed and deliberate, the expression of a man who had spent the recess doing something more than reviewing documents. "We're back on the record," he said. "Case number CV 2024, Fulton 8847, Meridian Property Holdings versus Walker." When he looked down at his notes, I've spent the past several hours reviewing the full record submitted by the respondent, Samuel Walker, as well as the supporting confirmation obtained through this court's direct inquiry with the Fulton County Department of Records and Archives. He paused. The central question in this case has been whether clear title to the Walker property is established or whether the chain of title contains an unresolved deficiency. He looked up briefly. The answer, based on the evidence now before this court, is unambiguous. He said it without drama, without theatrics, the way a judge is supposed to deliver a finding, matter-of-factly, because the facts were what they were. The lien release document filed on March 15, 1970, with the then-designated filing office, constitutes a valid and official resolution of the 1968 tax lien. The document is authentic. It has been on file with the county for 54 years. It directly addresses and closes the gap in the chain of title that the petitioner identified as the basis for this action. He turned to Monroe's table. "Miss Monroe, does the petitioner wish to add anything at this time?" Monroe stood. She was still composed, still professional, but the confidence that had animated her presentation that morning had been replaced by something more measured. "Your Honor," she said, "Meridian Property Holdings acknowledges the findings before this court. Based on the confirmed existence and validity of the 1970 lien release, the petitioner withdraws its claim of title deficiency and will not pursue further action against the Walker property under this or any substantially similar argument." A sound moved through the gallery, not loud, more like a collective release of breath. "The withdrawal is noted," Whitman said. He made a notation. Then he looked up. "I want to address something further before I close this proceeding," he said, "and I want it on the record." He looked at Samuel. "This morning, I conducted myself in a manner that fell below the standard this court should maintain. When Mr. Walker entered this courtroom to represent himself, I communicated skepticism about his ability to do so effectively. I did this before hearing a single argument. I did this on the basis of an assumption I formed rapidly, without justification, and without the impartiality that is the foundational obligation of this bench." He was speaking carefully, precisely, as though he had thought through each word during the recess. "I want to be specific about what I mean. My tone in the early portion of this proceeding suggested that I had already concluded the respondent was outmatched. That conclusion was wrong. My conduct created an environment in which that assumption was visible to everyone in this courtroom. That was not appropriate, and it is not consistent with the principles that should govern how this court treats every person who walks through that door." He paused. "Mr. Walker came here today with facts, with properly obtained documentation, with a logical and methodical presentation, and with more patience than this court deserved. He exercised his right to represent himself in a manner that should be instructive to anyone considering what it means to be prepared." He looked at Samuel directly. "I want to apologize to you publicly, and for that apology to be part of the official record of this proceeding. You deserved better from this bench today, and I am sorry that you did not receive it earlier." Samuel sat very still. He had not expected this. He had expected the finding, had been confident of it. He had not anticipated the apology, or at least not the form it took, public, direct, on the record, in front of everyone. He looked at Judge Whitman. "I appreciate that, Your Honor," he said, "and I respect what it took to say it." Whitman nodded. A brief, acknowledging nod. "This court finds in favor of the respondent," he said. "The Walker family's title to the property in question is confirmed as clear and unencumbered. All claims advanced by the petitioner are dismissed with prejudice." He turned a page. "Additionally, I am referring this case to the court's administrative committee, with a recommendation that the Fulton County Superior Court review its guidance to parties conducting title searches to ensure that records held by successor agencies to historical county offices are included as standard search locations. The record established today suggests that the current guidance is insufficient." He struck his gavel once. "This proceeding is closed." For a moment, nobody moved. Then the gallery came alive. Not with noise exactly, but with energy. The movement of people turning to each other. The press of bodies forward in their seats, the sound of someone in the back row beginning to applaud, and then stopping themselves because this was a courtroom, and that was not the done thing, but the impulse had been there, and everyone had felt it. Vanessa Walker rose from her seat in the second row. She pressed both hands over her mouth. Calvin put his arm around her shoulders. Samuel sat at the respondents' table for a moment longer. He looked at his documents, still organized, still arranged exactly as he had placed them. He picked up each folder and placed it back in his briefcase with the same deliberate care he had used when he took them out at 4:30 that morning. He closed the briefcase latch. He straightened his tie. Then he stood and turned to face the gallery. The steps of Fulton County Superior Court on a midday in October were not a place that typically attracted crowds. People moved through them with purpose, with the particular focused energy of people who had somewhere to be and something to resolve. On this Tuesday, however, a cluster of people had formed on the broad stone steps. Samuel came out through the main doors with his briefcase in one hand and his jacket buttoned against the cool October air. Vanessa was at his side. Calvin was just behind him. There were two reporters, a young woman with a recorder and a press badge from the Atlanta Journal-Constitution, and a man with a camera from a local television affiliate. They had clearly been waiting. Samuel stopped at the top of the steps and looked at them. The woman from the newspaper spoke first. "Mr. Walker, can you tell us how you're feeling after today's ruling?" Samuel considered the question. "Grateful," he said, "for the outcome and for the process. The system worked today. There were reports that the judge made remarks early in the proceeding that were inappropriate. How do you respond to that?" Samuel was quiet for a moment. He looked out at the street, at the midday traffic on Washington Street, at the buildings and the dry autumn trees, and the ordinary ongoing life of the city. "Judge Whitman acknowledged what happened," he said. "He did it on the record, directly, and without hedging. That matters. It actually matters a great deal." He paused. "I've spent a career in risk management. I know how difficult it is for institutions to acknowledge when something went wrong. What happened in there today, the acknowledgement, was not nothing. I'm not going to minimize it." The reporter nodded. "And the case itself? The property?" "The property is my family's," Samuel said. "It's been my family's since 1947. It's my grandfather's legacy. That was confirmed today. That's what I came here to establish." The television reporter spoke up. "Mr. Walker, you represented yourself against a major law firm. Did you consider that a risk?" Samuel looked at him. "Everything's a risk. The question is whether you've prepared well enough to manage it." He said it simply, without performance, and somehow that was the most memorable thing he said on those steps. The reporters asked a few more questions. He answered them honestly and without excess. When it seemed like the questions were moving in the direction of political commentary or broader social statements that he was not prepared to make on the steps of a courthouse, he declined with courtesy. "I'm not the story," he said at the end. "What's in the archive on Pryor Street is the story. What my grandfather filed and preserved and what the county kept safe for 54 years without anyone knowing it would matter on a specific Tuesday morning. That's the story." He descended the steps with his briefcase. On the sidewalk below, a man Samuel did not recognize was waiting. He was perhaps 45, wearing a good suit, with the bearing of someone accustomed to professional settings. He extended his hand. "Mr. Walker," the man said, "my name is David Osei. I'm a professor at Emory Law School. I was in the courtroom this morning. I hope you'll forgive the approach, but I wanted to speak with you." Samuel shook his hand. "Professor, what you did today in that courtroom," Osei said, "the preparation, the methodology, the way you presented, I've watched that case from the gallery, and I want to tell you that what you demonstrated this morning is exactly what we try to teach our students. And most of us, don't manage it as cleanly as you did." Samuel looked at him. "Thank you. That's kind. I'd like to ask if you'd be willing to speak with my class at some point," Osei said. "Not as a legal expert, but as someone who can speak to the process of preparation, of navigating institutional spaces when the institution hasn't exactly made it easy for you." Samuel was quiet for a moment. He thought about the early morning kitchen, the 4:30 alarm, The 6 visits to the archive, the retired land surveyor he had tracked down through a mutual acquaintance, the phone call to Patricia Hawthorne at the Department of Records and Archives. He thought about his grandfather's backyard steps. "I'll think about it," he said. And he meant it genuinely, as something to consider carefully rather than as a polite way of saying no. Osei gave him a card. Samuel put it in his jacket pocket. He walked toward the parking lot with his daughter and his brother through the midday Atlanta streets, through the October air that smelled faintly of wood smoke and coffee from a cart on the corner, and the city moved around them in its ordinary, magnificent way, indifferent to what had just happened, as cities always are. And somehow, that was fine. 3 days after the ruling, an article appeared in the Atlanta Journal-Constitution. It was not a front-page story. It ran in the Metro section, below the fold, under the headline, "Retired Veteran Defeats Corporate Property Claim in Fulton County Court." The article was roughly 800 words, reported by the young woman with the recorder who had been waiting on the courthouse steps. Her name was Angela Reeves, and she had been covering the Metro Court beat for 3 years, long enough to recognize when something that looked routine on the docket was not routine at all. The article got the facts right. It described the morning's events in sequence, quoted Samuel briefly, described the nature of the lien release document and the chain of title issue, and noted Judge Whitman's public apology. It mentioned that Samuel was a retired Army major who had served for 3 decades. It did not editorialize about what the case meant symbolically or historically. It reported what happened, and it let the facts carry the weight. Angela had written 3 drafts of the article before settling on the version she submitted. The first draft had leaned into the emotional dimension of the story, the underdog narrative, the black veteran versus the corporation, the judge who laughed. Her editor had read it and told her to pull back, not because those elements were not real, but because the story was stronger when the facts did the talking. So she had restructured it, moved the lien release document to the 2nd paragraph, let the procedural detail establish the stakes, and save the quote about the archive for the end. It was better that way, colder, more precise, and for that reason, more devastating. Within 48 hours of the article's publication, it had been shared extensively on social media. Several legal commentary accounts posted threads analyzing the procedural dimensions of the case. A podcast about civil rights and property law discussed it in a 20-minute segment. 2 other local television affiliates ran brief reports. A property rights advocacy organization in Washington, D.C., sent a formal letter to the Fulton County Court Administrator citing the case as evidence of systemic gaps in title search guidance nationwide. Samuel became aware of all of this gradually, through Vanessa, who was more attentive to social media than he was, and through colleagues who texted or called. His phone, which normally received perhaps 8 to 10 messages a day, received 43 in the 48 hours following the article's publication. Several were from people he had not spoken to in years. A fellow officer from his time at Fort Benning sent a message that said simply, "That's the most Army thing I've ever seen a civilian do." A former colleague from his risk management consulting work sent a longer message about the methodology Samuel had applied to the legal research and asked whether he had considered writing about it. He had not considered writing about it. He was not sure he had anything to say about it that the case itself had not already said. His response to the attention was the same as his response to the morning in the courtroom. He let it be what it was without adding to it. He called Professor Osei on Thursday afternoon and accepted the invitation to speak to his class. They scheduled it for the following month. Osei had mentioned that the class was composed of 2nd and 3rd year students, many of whom were already working in clinics that provided legal assistance to low-income clients in property disputes. Samuel thought that was a good audience. People who were already in the work and might know specifically where what he had to say could be applied. He called Patricia Hawthorne at the Department of Records and Archives and thanked her specifically for her assistance during his research. She told him she was glad the record had served its purpose and mentioned, with some professional satisfaction, that her division had fielded 3 additional inquiries about historical lien records in the 48 hours since the article ran. "People are looking now," she said. cases where somebody just didn't know to look there. That's good, Samuel said. That's the most useful thing that comes out of all of this. Orlan? There was a brief pause on the line, and then Patricia said something that stayed with him. You know, I've worked in this department for 19 years. We have records going back to the 1880s in some categories. Most of them never get requested. People don't know they exist, or they assume that if it matters, it would have shown up in the standard search. She paused again. It doesn't always work that way. There's a lot of truth sitting in this building that nobody's ever come looking for. Samuel thought about that for a long time after the call ended. He also received a letter from Judge Whitman's clerk. The letter was formal in language, as correspondence from a judicial office should be. It informed Samuel that Judge Whitman had submitted a formal recommendation to the Fulton County Superior Court's Administrative Committee regarding the revision of title search guidance. The letter also enclosed a copy of the recommendation itself, which ran to 4 pages, and cited the Walker case by name as the basis for the proposed revision. Samuel read the recommendation carefully. It was thorough. It addressed specifically the gap between what standard title search protocols required and what the records held by successor agencies to historical county offices actually contained. It proposed mandatory supplementary search locations, training updates for legal professionals who routinely conducted property title research in Fulton County, and a public notice advisory to be distributed through the County Bar Association. It was, in short, a real response, not a gesture, an actual attempt to prevent the same gap from producing the same injustice for someone else who might not have had the background, the resources, or the determination to find what Samuel had found. He thought about that category of person with some care. The person who did not have 31 years of military training in methodical problem-solving. The person who did not have a background in risk management that had taught them to assume blind spots in any system and go looking for them. The person who had received the same claim from Meridian Property Holdings and had looked at the legal fees and the complexity and had concluded that they simply did not have the tools to fight it. That person existed. Samuel was certain of it. In fact, he was certain that there were many of them. In Fulton County and in counties across Georgia and across the country, people who had received similar claims and had not been able to mount the kind of response he had mounted. Not because the facts were against them, but because the facts were in a place they did not know to look. That thought sat with him heavily, in a way that the outcome of his own case did not, because his own case was resolved. The others were not. He sat at his kitchen table and read the recommendation twice. Then he picked up his pen and wrote a letter back to Judge Whitman's clerk, formally acknowledging receipt and expressing his support for the proposed revisions. But before he sealed the envelope, he added a paragraph that had not been in his original draft. He noted that the systemic gap described in the recommendation was not unique to Fulton County, and suggested that the court might consider sharing the revised guidance framework with the Georgia Superior Court Judges Council for potential broader adoption. He kept the language measured and appropriately deferential, aware that he was writing to a judicial office and not submitting a policy memo. But he said what he thought needed to be said. He sealed the envelope, set it on the counter to mail in the morning, and went to the window. The concrete steps at the back of the house were where they had always been, solid, a little weathered at the edges, still holding. He stayed at the window longer than usual that evening. The backyard was dark by now, lit only by the glow coming through the kitchen window and the faint orange wash of the streetlight from the next block. He could see the steps clearly enough, 4 of them, leading down from the back door to the brick path that ran along the garden his grandfather had planted, and that various members of the Walker family had maintained and altered over the decades, until it looked like nothing that James Walker had originally designed and exactly like something a family builds over time when nobody is in charge of it and everyone has opinions. He thought about his grandfather, who had poured those steps himself one summer weekend in 1951, using forms made from scrap lumber and bags of concrete mix that he had carried from a hardware store 2 blocks away, because he did not own a truck and could not borrow one that weekend. James Walker had been that kind of man, a man who figured out how to do things without waiting for the conditions to be perfect, who treated every obstacle as an engineering problem rather than a verdict on whether he deserved to succeed. Samuel had come from that. He had come from that and from Carolyn, his wife of 27 years, who had passed 4 years before, and who had believed, without any particular sentimentality and with a great deal of practical directness, that the world rewarded preparation and patience more reliably than it rewarded anything else. She had said this in the context of many things over the years: school, work, relationships, decisions both large and small. She had a particular phrase that she used when Samuel was preparing for something difficult. She would look at him while he was going over his materials, reviewing his notes, running through scenarios in his mind, and she would say, "You're not doing this to impress anyone. You're doing this so you don't have to be surprised." He had thought about that phrase many times in the 8 weeks he spent preparing for the hearing. He had thought about it at 4:30 in the morning on the day of the hearing, sitting at this same kitchen table with his documents arranged in front of him. He had not been surprised. He turned away from the window and went to make coffee. While the coffee brewed, he opened his notebook to a fresh page and began writing. Not because anyone had asked him to, not for a publication or a class or a presentation, but because there were things he wanted to think through carefully, and he had always thought more clearly with a pen in his hand. He wrote about the research process. He wrote about the logic of looking for records not where standard protocols pointed, but where the history of the administrative system suggested they would logically have to be. He wrote about the particular challenge of property records from mid-century Georgia, where the mechanisms that black property owners used to secure their purchases were often outside the standard documentation frameworks, not because those mechanisms were less legitimate, but because the standard frameworks had not been designed with those buyers in mind. He wrote for about an hour. When he stopped, he had 4 pages of notes that were rough and partial, and not intended for anyone else's eyes, but that represented the beginning of something he could not yet fully name. He capped his pen, closed the notebook, and drank his coffee. Outside, Atlanta was settling into its nighttime self, and somewhere in a county archive on Pryor Street, 54 years of patient record-keeping was doing exactly what it had always done, holding the truth steady, waiting for someone to come and find it. 6 weeks after the ruling, on a Thursday evening in late November, Samuel Walker returned to Fulton County Superior Court. This time, however, he was not there to dispute anything. He had been invited by the court's Public Affairs Office to participate in an event called the Access to Justice Forum, an annual gathering that the court hosted for members of the legal community, law students, and members of the public interested in understanding how the court system worked and how individuals could navigate it effectively. The event was held in the courthouse's large ceremonial chamber, a room reserved for formal occasions, with high ceilings, wood paneling that had darkened with age into something rich and serious, and seating for approximately 150 people. On the walls hung framed photographs of previous chief judges, going back through the decades, their formal portraits arranged in chronological order, a visual record of institutional continuity. The room was nearly full when Samuel arrived. He came early, as he always did. He was met by a staff member from the Public Affairs Office named Rebecca, organized and efficient, who walked him to a green room adjacent to the ceremonial chamber and offered him coffee. He sat in a chair in the small room and looked at the index cards in his jacket pocket. He had written a few notes, not a full speech, just markers for the points he wanted to make, and the order in which he wanted to make them. He had learned long ago that overscripting a presentation was often worse than underscripting it. If you knew the material well enough, the notes were just a map, and you did not need to read a map aloud to use it effectively. He heard the chamber filling through the wall, the low murmur of a large group assembling, the scrape of chairs, the particular acoustic quality of a high-ceilinged room receiving people. Professor David Osei from Emory Law came into the green room at 6:20. He had brought 2 of his students with him, third years who were doing their capstone work in property law, and who stood slightly back from the conversation with the careful attentiveness of people trying to absorb everything, without appearing to be absorbing everything. "I've been thinking about what you did a lot since October," Osei said. "I hope usefully," Samuel said. Osei smiled. I've revised 2 of my course units. The way you approach the research, starting with the question of where the record would logically have to be, rather than starting with where standard searches look, that's something I should have been teaching more explicitly. My students do the textbook steps and then stop. You did the textbook steps and then asked what the textbook was missing. That's risk management thinking, Samuel said. You assume the system has blind spots. You look for them before they find you. That's exactly it, Osei said. And it applies to legal research as naturally as it applies to anything else. The question is always, what does the standard framework assume? And where does that assumption break down? One of the students, a young man named Marcus, spoke carefully. Mr. Walker, in your research, how did you know where to look outside the standard search? What was the reasoning? Samuel considered him for a moment. He liked the precision of the question. I asked myself where the record would have to have been filed given the administrative structure that existed at the time, not where someone today would file it, where a county officer in 1970 would have put it, given the offices that existed and the procedures that were in place then. He paused. Institutions change. They merge. They rename. They reorganize. But the records don't disappear. They get absorbed. If you can reconstruct the history of the institution, you can follow the records to where they ended up. Marcus wrote something in his notebook. Rebecca came to get them at 6:40. They went into the ceremonial chamber together. The event had a formal structure. A court administrator opened with remarks about the court's ongoing commitment to accessibility and transparency. A representative from the Legal Aid Society spoke about the gap between the legal needs of the general public and the legal resources available to address them. A gap that was measurable and stubborn, and that the court system was obligated to take seriously. A panel discussion had been organized to follow, with Samuel, Judge Whitman, Professor Osei, and a senior attorney from the Fulton County Public Defender's Office named Denise Crawford. Denise Crawford turned out to be one of the sharper minds in the room. She had spent 18 years in the Public Defender's Office, had tried hundreds of cases, and had very little patience for institutional self-congratulation. When the court administrator finished his opening remarks, she leaned over to Samuel and said quietly, "The gap between what they said just now and what actually happens in this building is a very interesting subject." Samuel looked at her. "Do you say that out loud up there?" "Every chance I get," she said, without expression. He liked her immediately. The administrative committee representative spoke first during the panel portion, describing the procedural updates that had been approved in response to the committee's review. The new guidance on supplementary search locations for title research had been formally adopted. Training updates for the County Bar Association were scheduled for the new year. The Public Notice Advisory was already in distribution and had been acknowledged by the Georgia Real Estate Commission as consistent with their own updated guidance on title research best practices. Samuel listened and felt something that was neither pride nor satisfaction exactly, but was adjacent to both. Something quieter. The feeling of a thing having been done correctly, of a process that had started with a man at a kitchen table at 4:30 in the morning, ending with an institutional change that would affect how property disputes were handled in Fulton County going forward. That was not nothing. That was, in fact, something durable. Judge Whitman spoke next. He had agreed to participate in the event, which Samuel had been told was not common for sitting judges with respect to public forums of this kind. Judicial restraint about public commentary was a professional norm with real purpose, and departures from it were not made casually. He had been told that Whitman had specifically requested to be included, and that the request had surprised the Public Affairs Office. When Whitman spoke, he did not speak about the legal mechanics of the Walker case. He spoke about what it meant to be a judge, about the responsibility of impartiality, about the ways in which assumptions formed before a proceeding began could shape the proceeding in ways that were invisible from the inside and fully visible from the outside. "We use the word impartiality in this profession constantly," Whitman said. "It is in our oaths. It is in our standards of conduct. It is in the language we use to describe what a judge is supposed to be." He paused. "I want to suggest that impartiality is not a default state. It is not something you achieve by doing nothing. It is an active discipline. It requires you, every single time you enter a courtroom, to examine what you are bringing in with you and to set aside what does not belong. He looked at the room evenly. I did not do that adequately on the morning of October 14th. I brought in an assumption I had not examined. It shaped my conduct in those first minutes in ways that I have thought about carefully since. I am not going to stand here and tell you that one case has resolved everything, because it has not. What I can tell you is that it changed how I enter a room, which is, I suppose, what accountability is actually supposed to produce. He sat back, and for a moment the room was very still. Then Denise Crawford spoke, and the stillness broke in the best possible way, because Crawford was not interested in ceremony and said clearly and with complete professional calm that the issues Whitman had described were not limited to individual judges on individual mornings, that they were structural and repeated and documented, and that the mechanisms for addressing them needed to be as systematic as the problems themselves were. She said it without anger, with the particular force of someone who had been saying the same thing for 18 years and was not yet ready to stop. The room responded to her differently than it had responded to Whitman, where Whitman's remarks had produced respect and a certain solemnity. Crawford's produced recognition. People in the audience were nodding. Law students in the front row were writing rapidly. Samuel spoke last. He had 15 minutes on the agenda. He used 12 of them. He talked about his grandfather's land and what it meant to inherit something built in conditions that were actively hostile to its building. He talked about the research process with enough specificity to be useful, naming the Georgia Archives, naming the Office of Tax Line Administration, and its absorption into the current Department of Records and Archives, naming Patricia Hawthorne and what her knowledge of the filing system had made possible. He named the retired land surveyor, a man named Robert Tillman, who lived in Decatur, and who had explained to Samuel the documentation conventions used by certain county offices in the 1960s and 70s that differed from the conventions used today. He gave people the specific details because the specific details were the point. Anyone could say, go look in the archive. The useful thing to say was which archive, which division, which records category, and how you would know what you were looking for when you found it. He talked about preparation. There are moments in a proceeding, he said, where the temptation is to react to how you're being treated rather than to what you came there to accomplish. I felt that temptation on the morning of October 14th. I am not going to pretend I didn't. Several people in the room smiled, including, he noted, Judge Whitman. But I had come to that courtroom with a specific purpose. I had prepared to fulfill that purpose. Every moment I spent reacting to something other than that purpose would have been a moment taken away from the work, and I could not afford that. He paused and looked at the room. I want to say something about patience, because I think patience gets misunderstood. People sometimes describe patience as passivity, as waiting, as accepting a situation without responding to it. That is not what I mean. The patience I'm describing is the patience of someone who knows that the outcome they need requires time to establish properly, and who is willing to invest that time rather than shortcut the process. It is active, it is disciplined, and it is, in my experience, the thing most likely to produce a durable result. He looked at the students in the front row. The truth was in the archive. It had been there for 54 years, preserved by county employees doing their jobs carefully, without knowing that any specific record would matter on any specific Tuesday morning. The truth was patient. It just needed someone to go find it. He paused for the last time. Go find the truth. Document everything. Be respectful even when respect is not being returned. And trust that if the facts are on your side, and you have done the work to establish them, the process can lead somewhere right. Not always. Not quickly. But it can. And when it does, the result is something that lasts. He sat back. The applause was immediate and full, the kind that a room gives not out of obligation, but out of genuine response to something that had landed. Afterward, in the corridor outside the ceremonial chamber, Samuel stood for nearly 40 minutes. People came to speak with him, one after another. and he gave each of them his full attention. A retired postal worker who was in the middle of a property dispute in DeKalb County and wanted to know specifically whether the same kind of lien record might exist for his situation. Samuel told him honestly that he did not know, that every case was different, but that the principle of looking at where the administrative office that would have handled the filing had been absorbed was worth pursuing with an archivist. He suggested Patricia Hawthorne by name. A law student from Georgia State introduced herself. She was perhaps 26, professional in her bearing, with a law school lanyard and a notebook that had clearly been used extensively that evening. "Mr. Walker," she said, "I want to ask you something, and I hope it's okay." "Go ahead," he said. "How do you stay calm when the system is treating you like you don't belong there?" Samuel looked at her for a moment. He thought about the best answer, not the most inspiring one, not the one that would sound best repeated, but the most accurate one. "Because I know exactly why I belong there," he said. "When you know your facts, when you've done your homework, when you know that the truth is in the archive, and you have the papers in your briefcase to prove it, no one else's opinion of why you're there can override the actual reason you're there." He paused. "Their opinion of you is information. You can note it, you can understand it, you can even use it to adjust your approach, but it cannot touch the facts. And the facts are what you went there to present." He paused again. "Know why you're there. Know it so completely that it takes up the space where the doubt would otherwise go. The rest gets manageable." She wrote it down. He watched her write it, and something about that, the simple fact of a young person writing down something he had said because it seemed worth keeping, moved him in a way that he was not entirely prepared for. He shook her hand, said good evening, and walked down the corridor. Denise Crawford caught up with him near the exit. "Good talk," she said. "Yours too," he said. "I meant what I said in there," she said, "about the systemic piece. One case changes the guidance in one county. That's real. It's also partial." "I know," he said. "Are you going to do anything with that?" she asked, in the tone of someone who had decided she was going to be direct. He looked at her. "I'm thinking about it." She handed him her card. "Think faster," she said, and walked back toward the ceremonial chamber. He stood in the corridor for a moment with her card in his hand. Outside, the November air in Atlanta had turned genuinely cold, the kind of cold that came after dark in the weeks before Thanksgiving, with a sharpness to it that cleared the mind. He stood on the side steps of the courthouse for a moment and looked at the city. Atlanta at night, the office towers lit against a dark sky, the distant sound of traffic moving through its arterial rhythms, the amber wash of streetlights along the quieter blocks, the ordinary, ongoing, extraordinary life of a city that had been through more than most and had not finished. He had lived here most of his adult life, had left it for deployments and assignments, and come back to it with the particular loyalty that people develop for places that have known them at different stages. He thought about his grandfather, who had never stood on these steps but had built the steps at the back of a house in southwest Atlanta, and trusted that they would hold. They had held. He thought about Carolyn, about her phrase, "You're not doing this to impress anyone. You're doing this so you don't have to be surprised." He thought about all the people in that room tonight who were doing the work of not being surprised, who were building the kind of preparation that made it possible to walk into a difficult space and stay anchored. He thought about the notebook on his kitchen table, with 4 pages of notes in his handwriting that were the beginning of something he could not yet fully name, but that Denise Crawford's card in his pocket was nudging toward a shape. He put her card in his jacket pocket, next to his index cards. He picked up his briefcase, buttoned his coat against the November air, and walked down the steps toward the parking lot, through the cold and the dark and the particular alive stillness of a city on a Thursday night, carrying what he had come with, and a little more besides. Behind him, through the courthouse walls, the Access to Justice Forum was still going. People were still asking questions, still trying to understand how to navigate something large and imperfect, and worth navigating anyway. He had said what he came to say. The work, as it always does when done honestly, would continue.